Well, I'm going to begin recording here in just a minute. I'm going to begin the lecture in a second. Today's lecture is going to be on involuntary commitment. And I know your book has nothing on involuntary, at least it doesn't have a chapter on involuntary commitment. But involuntary commitment is probably one of the more important things that forensic psychologists do. And it's important for a number of reasons. One is because there are times when individuals have a mental illness that is so severe that they need to be treated even though they don't want to be treated. This is particularly true of individuals who have severe and persistent mental illness, and we can talk about the SPMI issue here in just a minute. Um, Let me share my screen here for a second about the SPMI issue. Um, when we talk about the whole issue of, let me bring this up, it's called SPMI for severe and persistent mental illness. Those of you who have had me for abnormal psychology know that I emphasize considerably in that course that not all mental illnesses are lifelong. In fact, the majority of mental illnesses are temporary situations for a lot of people. With current treatment strategies, with our current understanding of mental illness, with current medications and other forms of treatment, the majority of people who suffer from mental illness can and do get better. Some of them get better to the point where they are no longer mentally ill. This is particularly true for depression. Not everybody who has severe depression needs to take depression for their entire lives. Many people with severe depression end up getting better within 1 to 2 years and not having any depressive episodes, at least not in the sense of a mental illness, for the rest of their lives, or at least for as long as we follow them, which is about 10 or 12 years, but still, it's a long time. Post-traumatic stress disorder is not the death sentence that it once was. What I mean by that is people no longer have to have PTSD for their entire lives. There are many, many different types of treatment for PTSD, only one of which involves medications, but there is rapid eye movement desensitization treatment, which works well for some individuals. There is dream therapy, which works well for some individuals. There's cognitive behavior therapy, exposure therapy. There are a number of therapies for PTSD that can help individuals to recover from it. So while I do emphasize in abnormal psychology quite frequently that mental illness isn't something that a person necessarily needs to deal with for life, there are some individuals, however, who do suffer from mental illness, and it's a lifelong condition. It's a lifelong issue. And so when we get into severe and persistent mental illness, we're talking about those mental illnesses that are persistent. That is, these are lifelong illnesses. The best the person can manage is to learn how to manage the symptoms, to learn how to cope with the symptoms, to learn how to live as effective a life as possible with the symptoms. And I use the diabetes model for this quite frequently, and that if somebody has diabetes, and the only thing they're doing is taking their insulin, they're not going to get their diabetes under control. Not going to happen. In addition to taking the insulin or whatever medication they're taking, they need to monitor their diet. They need to watch what they eat. They need to deal with the stress because high levels of stress make it very difficult for the body to utilize the insulin that they're taking and keep their blood sugar under control. They need to exercise because one of the problems that diabetes has is it creates constriction in the peripheral veins and arteries. And so the individual needs to exercise to keep the blood flow going so they don't develop what's called peripheral neuropathy, where the fingers and the toes and ears and the external parts, the exterior parts of their body start to actually die off because of lack of blood flow. So somebody who has diabetes needs to have a comprehensive plan because this is a lifelong illness. And if they do that, they can manage the diabetes reasonably well. They can lead a reasonably normal life, and they might not be able to eat chocolate cake for dessert, but they can certainly have a reasonably normal life despite the fact that they're struggling with diabetes. Apply that to persistent mental illness. And there are many people with persistent depression, many people with persistent schizophrenia, bipolar disorder, other severe mental disorders who can lead a relatively normal life, a relatively uh, pleasant, effective, satisfying life. So the severe and persistent mental illness diagnosis and criteria is a very important one for us to understand. It includes those individuals for whom their mental illness is, number one, severe to the point that it makes it difficult for them to function effectively, and persistent, that is, it's not going to go away. Now, in our society, in American society, we believe very strongly, and I personally believe this as well, that individuals have autonomy. Individuals have the right to make decisions about their health care, about whether they take or don't take medications, about whether they are or are not hospitalized. Now, I may disagree with somebody's medical decisions. I may think, well, you're just setting yourself up for problems. But in our society, we believe very sincerely and very strongly in this concept of autonomy, independence, individual responsibility, and an individual's right to choose. However, there are times when an individual's mental illness is so severe that the individual is not able to exercise their right to choose. This is where psychologists come in very much. Now, I want to talk for a minute. I want to move a little bit away from commitment to, I want to talk for a minute about an issue called guardianship. Guardianship. Guardianship is a situation in which an individual who otherwise would have the right to self-determination loses that right, and someone else has the responsibility and the right to make decisions for that person. In a guardianship situation, an individual no longer has the legal ability to decide for themselves things like money, things like medical care. And so in North Carolina, there are two types of guardianship. One is guardianship of the person, meaning that the individual who is appointed as guardian is able to make decisions for the person. These include decisions around medical care, around where the person lives, that is housing, is able to make decisions about the individual's living situation, medical situation, whether the individual goes to school and what type of school the person does. So all of those decisions that individuals generally make for themselves about their own person, the guardianship now has the legal right to make for the person, and the person loses that right for themselves. The second type of guardianship is guardianship of the estate. This involves involves decisions regarding money, finances, work, okay? And so an individual who is guardian of the estate means that the individual has lost their ability to decide what they do with their own money. They cannot have a checking account or a bank account unless the guardian approves and unless the guardian is a co-owner of that checking account or savings account. The guardianship of the estate decides whether the individual can work and what happens with the person's wages. Again, this is very much against what we Americans believe. We believe that people should make decisions about their own care, their own lives, Whether they go to school or don't, what they do with their own money. You have the right to make those decisions as an adult, as a fully integrated member of society. However, I go back to the severe and persistent mental illness issue, that there are times when an individual's mental illness interferes with their ability to make those decisions, and uh, the court appoints a guardian for that individual to make the decision for them. In looking at the whole guardianship issue, the guardian also makes the decision as whether the person takes medications or not. Um, Now, oftentimes the guardian is a family member, sometimes a mother or father, sometimes a brother or a sister, close family members. But in the case where the guardian, where the individual has no family members who are capable of taking care of them or want the responsibility to take care of them, that's where the state comes in. And this is where adult protective services takes over. Every county department of social services has an adult protective services division, which basically one of the functions of adult protective services is to serve as guardian for those individuals whose mental illness is such that they're not able to serve as their own guardian. Now, the severe and persistent mental illness, what leads somebody to guardianship is, number one, the individual has to have a form of mental illness. The form of mental illness most common in guardianship situations is intellectual disability. This is probably the most common diagnosis for guardianship. An individual whose intellectual functioning is so low that they can't manage their own. Intellectual disability is a diagnosis that basically only a psychologist can make, because intellectual disability involves intelligence testing and adaptive functioning testing. And I'm not going to get into the diagnosis of intellectual disability as beyond the scope of this class, but basically just to state that intellectual disability, which is generally diagnosed by psychologists, if it is severe enough, would qualify a person for guardianship. That is, would make the individual impaired enough that they would lose their right to self-determination. Other diagnoses that individuals sometimes have is substance abuse. Now, I want to talk for a minute about temporary guardianship, and I want to talk about permanent guardianship. Certainly somebody with an intellectual disability isn't going to get any better. And we have no cure for intellectual disability. Well, we have treatments that help individuals function more effectively. An individual with an intellectual disability is going to have the intellectual disability forever. They're never going to get better. They're never going to become average functioning again. Somebody with a substance abuse problem, on the other hand, can and often does remit if the substance abuse disorder is severe enough that the individual is not able to make good decisions. Now, notice I said not able to make good decisions. If somebody is able to make good decisions, but makes crappy decisions anyways, that's not grounds for guardianship. You know, I make crappy decisions all the time, and thank goodness I haven't had a guardian. So you know, just because somebody's making bad decisions doesn't make them eligible for a guardianship. However, if the substance abuse does interfere with the individual's functioning to a significant degree, then they can qualify for temporary guardianship. And when they are free of the substance abuse, they've had a period of sobriety, generally a period of a year or two, they can petition to have the guardianship removed and become their own guardian again. That is, as the terminology is, they become their own guardian, meaning that that their right to self-determination is restored to them. So substance abuse is a criteria for um, guardianship. Other mental illnesses that involve guardianship are any mental illness that results in a psychosis. Now, psychosis is not a mental illness by itself. It is not. Psychosis is the result of a mental illness. What psychosis means is that the individual is out of touch with reality. They're hallucinating, which is a sign of psychosis. They're severely delusional, which is a sign of psychosis. Um, they're not able to correctly recognize or interact with individuals in their lives. That is a sign of psychosis. So psychosis is when an individual is clearly out of touch with reality. Their thinking, their perceptions, their way of doing things is clearly disturbed and dysfunctional. The various different types of diagnosis that often result in psychosis are schizophrenia and other schizophrenic disorders. Very much schizophrenia is a form of psychosis. Matter of fact, I don't know too many people who have schizophrenia who are not psychotic unless they're being treated. I know a number of people who are being successfully treated for their schizophrenia, and they're not psychotic while they're being treated. So schizophrenia does not necessarily mean, diagnosis of schizophrenia does not necessarily mean that somebody is going to necessarily need a guardian, but sometimes it can. Sometimes it can. Bipolar disorder, if it is severe enough. Depression, major depressive disorder, if it is severe enough, can result in psychosis. PTSD, if it is severe enough, can result in psychosis. So there are many, many different severe diagnoses that can result in psychosis and that qualify for the severe and persistent mental illness criteria. So the first criteria that's necessary for a guardianship, and we're going to talk about commitment in a minute. I'm going from here to commitment, and we'll talk about that. But the first criteria is that the individual must have a severe mental illness. If you've got major depression that's mild, you're not going to qualify for a guardianship. If you've got PTSD that is well controlled, you're not going to qualify for a guardianship. So don't worry about losing your rights just because you have a mental illness. We don't do that anymore. Thank goodness. It has to be severe. And the second criteria is that it is not just a mental illness, it is a mental illness plus the individual is unable to make decisions as a result of the mental illness. They lack the ability to understand the consequences of the decisions they're making. They lack the ability to be able to weigh the different consequences, the different alternatives. So I take medications, has side effects, but I don't have the symptoms. Don't take medications. I don't have the side effects, but boy, I do have some severe symptoms. Do I have the mental capacity? Do I have the mental ability to be able to weigh those options and come to a decision based upon my ability to weigh those? Now, that doesn't mean a decision that other people agree with, but a decision that makes sense given where I'm at and given my preferences and my abilities and capabilities. Now, so this is guardianship. And as I'm talking about here, what guardianship involves, and as I mentioned earlier, we have guardianship that is temporary versus permanent guardianship. Although I'll be honest with you, nothing in our country is permanent, thank goodness. Even so-called permanent guardianship, the individual can petition the court. The individual who has a guardian can petition the court and ask that the guardianship be removed. The burden of proof is on the individual to prove that whatever condition, whatever mental illness they have, has gotten sufficiently better to allow them to start making decisions for themselves. And courts are rather reluctant to do that because they don't want people on guardianship, off guardianship, on and off and on and off and on and off, which sometimes happens with some severe and persistent mental illnesses. The courts like to have some sort of finality to these things, even though, as I mentioned before, nothing in this country is ever really totally permanent except death. That's kind of permanent. I don't know of anybody who's I don't personally know anybody who has, in my lifetime, come back from the dead. Maybe I will in the future know somebody, but personally in my lifetime, but not now. So permanent guardianship, temporary guardianship, however, is often for a particular period of time, or it is recognized that the individual is going through a really bad time. The condition is likely to get better, but at this point in time, they need somebody to make the decisions for them because they're not capable of making those decisions themselves. So let's talk a little bit about commitment. And again, this kind of gives you a bit of an overview of where we're at here, because commitment is like guardianship in the sense that the individual is their right to decide has been taken away from them because of their mental illness or substance abuse problem. And in the DSM, mental illness is mental illness. The whole issue of substance abuse and intellectual disability being different from mental illness comes about from the 1960s. And I could give you a history lesson on that, but basically what it was in the 1960s, when our mental health system was being initially developed, we were starting to develop the community mental health centers, and John F. Kennedy signed the Community Mental Health Act, establishing federal funding of community mental health centers. The Community Mental Health Act established 3 pots of money. There was a pot of money for people who were intellectually disabled, a pot of money for people who had mental illness, and a pot of money for people who had substance abuse. These 3 pots of money were distinct and separate, and an individual could get services from one pot of money at a time. Okay, so we had this issue of these 3 separate categories of mental and behavioral problems. In reality, the DSM makes no distinction between them. They are all mental illnesses. You have a substance abuse problem in the DSM, that's a mental illness. Now, I know some of my good friends who are substance abuse counselors, they say, no, substance abuse is not a mental illness, it is, and then they go off on what substance abuse is. And it doesn't matter. To us psychologists, it's all the same. It all comes out of the DSM. It's all in the same pot. And while it's useful to kind of separate it out in terms of treatment, it's not useful in terms of dealing with issues like guardianship or diagnosis or things like that. So anyways, so we've got the severe and persistent mental illness issue here. Now I'm going to change my, and I think I brought it up here. I did a PowerPoint, and I know I've been doing a lot of PowerPoints lately in some of my classes here. Let me get out of this for a minute. Stop the share for a second. Let me start the recording again. I'm going to share my screen and share the commitment training here. There we go. Okay, so I did this training a number of years ago for the magistrates in Catawba County. When I was the director of the mental health agency, the Catawba County magistrates wanted some training on involuntary commitment in North Carolina. Now, while the laws have changed slightly since this time, and while the commitment process in North Carolina is slightly different from what it is in other states, the basic principles are exactly the same. Exactly the same. Involuntary commitment involves an individual being committed to a hospital, to a treatment facility against their will. That's what the term involuntary means. The person is not agreeing to it. It's just they're doing they're basically they're being play they're it's like being placed in jail. They're taken into custody just as they would if they were being arrested, and their detention facility is a hospital instead of the county jail. And so let me see here. Okay. There we go. So the training is looking at the commitment laws in North Carolina. And we're going to, and in this training, we looked at the roles of the magistrates, law enforcement, mental health agencies, and so on. I'm not going to go through all of the slides in the training. I'm just going to cover those that are useful for us and useful for you as you look at this week's case study. So when we take a look at this week's case study, keep in mind that yeah, we did this in terms of making the process work more effectively in Catawba County, and looking at the commitment process for that. So involuntary commitment law come from the general statutes of North Carolina. And in North Carolina, there are three types of involuntary commitment. There is inpatient commitment, where the individual is placed in a hospital. And by the way, the GS and so on, these are all the legal statutes that allow this to happen. These are the legal statutes that basically outline and identify the involuntary commitment process in North Carolina. So inpatient commitment involves the individual basically being placed in a hospital involuntarily for a period of time for treatment. Outpatient commitment, as the name implies, requires the individual to receive services in an outpatient facility. And so an individual on an outpatient commitment must show up at an outpatient facility every day or as often as mandated until they are successfully treated and no longer eligible for or no longer meet the criteria for an involuntary commitment. And then the third type of commitment is a substance abuse commitment. The difference between the substance abuse commitment and the inpatient and outpatient commitment is just that. Substance abuse commitment is for individuals who have a substance abuse problem. So if any of you have a family member that you believe you need to get a commitment on, this is the law that applies to the commitment. So when we go down here, okay, and one of the things is that minors, those under the age of 18, are subject to the same procedures as adults. It doesn't matter what age somebody is. Now, if the parents will consent to their child being placed in a psychiatric facility, then the involuntary commitment process stops because the child has no say-so. The parents are placing them in the facility, so there is no need for the court to get involved. There is no need for this process to continue. However, if the parents are not agreeing to it, or if the parents prefer to go to the involuntary commitment route, then the process for a minor is exactly the same as the process for an adult. Okay, and so it doesn't matter for minors. The inpatient commitment, the individual must be mentally ill, as we talked about, dangerous to self or others, and in need of hospitalization to present harm to self or others. In North Carolina, the dangerousness to self or others is critical. Now in California, California adds a third category for those of you who are interested. That is, an individual must be dangerous to themselves, dangerous to others, or this is the California's third category, gravely disabled. That is, if the individual is so disabled that they are unable to care for their needs, then they can be involuntarily committed in an inpatient facility. Now, North Carolina doesn't have that third category of gravely disabled. North Carolina basically states that somebody who is that gravely disabled is in fact a danger to themselves and would fall under the danger to self category. Keep in mind that dangerousness to self or others does not mean that the person is necessarily threatening other people. In other words, I don't have to be pointing a gun at you to be dangerous, to be declared dangerous to you. I don't have to be threatening to hurt other people to be considered dangerous to you. Let me give you an example. And this, I love this example because I did the commitment evaluation on this woman. This woman was severely mentally ill, had severe schizophrenia, and was incredibly delusional. And she believed that she could telepathically make lights change, the stoplight change as she was coming up to it. She believed that all she had to do was think green, think green. She'd go green, 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 and the light would change green. And so she was going through red lights on Highway 70, down by the mall area there, from 321 to the mall area. She was going through red lights at 70 miles an hour because in her mind the lights were changing to green. Now she was not threatening other people, did not have a gun to other people's heads, but as a result of going through those red lights at 70 miles an hour, you don't think she was a danger to others? I did. And the magistrates agreed with me, and the judge who oversaw the involuntary commitment agreed with me that this was clearly a danger to other people because driving her car through red lights because she had the mistaken belief that she could think them green was a danger to others. Dangerous to self doesn't mean that the individual is suicidal. Suicidal can be dangerous to self, but not necessarily dangerous to self. And let me give you an example of this. I worked with an individual, another individual, again, had schizophrenia, and he was absolutely convinced that the FBI had placed an electrode inside his head and that they were transmitting information from the Duke power meter outside his house. And he had a crowbar and he was going to take that Duke power meter off and disable it. Now, do you know how many volts of electricity and how many amps and so on are going through that Duke power meter? If he had been successful, we would be putting a crispy person in a casket. So he was judged to be a danger to self because his behaviors were such that if he were permitted to continue, they would result in severe harm to himself. And again, dangerous to self doesn't necessarily mean that the individual is suicidal, that they're going to kill themselves, but their mental illness causes them to engage in behaviors that could lead them to commit serious harm to themselves. Could lead to amputation, could lead to whatever. Now I know you might say that your Uncle Bubba and saying, hey, y'all watch this, engages in behaviors that are dangerous to himself. The question has to be, is your Uncle Bubba mentally ill? And if the answer is no, then he can do all that crazy stuff and he's not going to be involuntarily committed. The issue, if somebody is severely mentally ill and doing all kinds of crazy stuff, that's when we can commit them. So don't be going down to the magistrate to take papers out on your Uncle Bubba and try to get him inpatient committed, because unless you can show that he's mentally ill, it isn't going to go anywhere. Okay. The third criteria here is that they need hospitalization. That is, anything short of hospitalization is not going to be effective in preventing the harm to themselves or others. So one of the basic premises of American mental health system is that we want to provide people care in the least restrictive environment. We want to provide them care in the environment that is going to restrict their rights the least. So we only want to commit them to a hospital if nothing less will work. And if we have evidence to suggest that nothing less will work. Again, the man who was trying to pry off the Duke power meter from his house to disable the transmitter that was transmitting stuff to his brain, nothing other than hospitalization was going to work with this guy. The lady who was driving 70 miles an hour down the road, thinking green and running through red lights, nothing less short of hospitalization was going to keep her from harming other individuals as she drove her car. So these three criteria are the basic criteria for inpatient mental health, and these criteria are similar regardless of the state. Different states may define these a little bit different, but nationally this has become pretty much the standard for involuntarily hospitalizing someone. Okay. Outpatient commitment. The person must be mentally ill. Okay. The basic for all of these is the person must be mentally ill. The person must be capable of surviving safely in the community with available supervision. So the big difference between outpatient commitment and inpatient commitment look the same, with the exception of this one caveat. That is, the person must be capable of surviving safely with available supervision. That is, they've got a mother, a father, a spouse, a friend, somebody who is able to supervise them adequately to ensure that they are not doing things to harm themselves or to harm other people. This is why most individuals who are suicidal do not get committed to the hospital, is because with appropriate supervision, with appropriate care from their parents, from their loved ones, they're able to do okay until they can get the treatment they need to reduce their suicidal ideation. Okay, come on, there we go. Based on psychiatric history, this is for outpatient as well, the person is in need of treatment to prevent further disability that would result. That is, based upon the person's history, treatment is necessary or they're going to get worse. That's what this says here. We don't want them to get worse, and then need inpatient treatment. Current mental status or illness can limit or negate an informed decision to seek voluntary treatment. What this means is the person's current state of mind and the current severity of their illness does make it so they cannot make informed decisions. That is, their mental illness limits their ability to make decisions for themselves. Okay. Substance abuse commitment then. They are a substance abuser. So we have to establish that they are actively abusing substances. Notice this does not say addict. And I say this in my abnormal psychology class. The word addict does not appear in the DSM. Addiction is not a mental illness. Addiction is not a psychological problem. Addiction is a medical problem, a medical issue. Not everyone who is addicted needs treatment. I'm addicted to caffeine. I will admit I'm addicted to caffeine. I must have my morning cup of coffee. If you were to look behind me here, let me see, I'll turn a little bit here. You see behind me? See what's behind me? Got a coffee pot. I drink caffeine. I'm addicted. I don't have caffeine. I go through withdrawal. I'm addicted to caffeine. And yet I am not in need of treatment. Addiction by itself does not meet the criteria for being a substance abuser. Now, maybe you can say I abuse caffeine. Okay, I'll give you that one. A substance abuser, by definition of DSM, by definition, is someone whose use of substances is having a negative impact on their ability to function. That is the definition of a substance abuser. Their use of psychoactive substances is interfering with their ability to effectively function in one or more roles, as a student, as a husband, as a wife, as a worker, as a parent. Their substance use is causing them problems in those areas. And as a result of their substance abuse, they are now dangerous to themselves or others. Not everyone who is a substance abuser is dangerous to themselves. It must, and when talking about substance abuse, let's talk about this dangerous to self or others for a minute. The law and the requirements require that dangerous to self or others involve imminent danger. That is, the individual is likely within the foreseeable future to do something that will harm themselves or others. Not in the distant future. So you can say, well, my father, brother, husband, whoever is drinking alcohol and it's going to eventually kill them. That's not dangerous to self. That is in the distant future. If their drinking is causing them to have significant problems now that make them a danger to themselves or others now, then they meet criteria for the substance abuse commitment. But to say, well, he's drinking so much, but I'm afraid he's going to do something in another couple of hours, doesn't count. Doesn't count. The couple of hours aren't here yet. And who knows, he may pass out before then and not do something to harm himself or harm other people. Has to be imminent danger, has to be in the foreseeable future, has to be something that can be predicted based upon his or her current behavioral circumstances. Third criteria is that they then need hospitalization. They need to be locked up in order to prevent harm to self or others. Keep in mind that outpatient commitment is a form of incarceration. The individual is locked up in a hospital. They cannot leave. Their right to self-determination has been severely limited. And as a free society, we take that very, very seriously. I, as a psychologist, take that very seriously. I do not lock people up unless there is a good reason to do so. And simply because somebody's being a jerk or saying that they're going to blow somebody's head off, that is not necessarily enough. Now, saying they're going to blow somebody's head off might necessarily be enough, depending on, do they have a gun? You know, how serious are they? Have they identified the person? You know, there's a number of other factors that go into it, but simply that statement alone doesn't count. And then treatment can be either on an outpatient or 24-hour facility as determined by the supervising physician. So this is another big difference between substance abuse and mental health commitment, is with substance abuse commitment, the supervising physician makes the determination as to whether it's in a 24-hour locked facility or it is in an outpatient facility where the individual goes, 3, 4, 5 times a week, 6 or 7 times a week sometimes, to the treatment facility. So these are the definitions of mental illness. By the way, this slide, series of slides is in your files section of Canvas. I would encourage you to kind of take a little look at it if you want more information. But we do have definitions for mental condition. For a minor, it is a mental condition other than, and it used to be called mental retardation, it's now called intellectual disability. So for a minor, intellectual disability is not sufficient to have an outpatient commitment. And then age adequate self-control or judgment is the impairment here. And so in the conduct of his or her social relations, if I can let you watch, you can watch this, you can stop the video here and watch it a little bit later if you want. So we're going to go on to the adult one here in just a second. Here we go. As applied to adults, mental retardation is included in the mental illnesses, excluded for juveniles, included for adults. Big difference between adults and juveniles. So a juvenile who has an intellectual disability, remember, when you read mental retardation in these old slides, think intellectual disability, intellectual disability. Dr. Capoletti probably needs to update this slide to use the current language, but I haven't done that yet. If anybody wants to do that, it's an extra credit activity for somebody that would want to update the slide, but be that as it may. So including mental retardation. That so lessens the capacity to use self-control, judgment, discretion, and so on. I'm not going to get into this. You can read it yourself, but this is what mental illness is by law. This is the legal definition of mental illness. This is the definition that applies to guardianship. It also applies to outpatient commitment. And as I said, this is one of the more important things that we psychologists do, is to evaluate for outpatient commitment. Yes, I have done a lot of these evaluations in the past. I don't currently do any of them because I don't work for a treatment facility that does them. But in the past, I used to do at least 2 or 3 of these a week. It was a major part of what I did as the director of the mental health agency. Definition of mental retardation. You can, and again, change mental retardation to intellectual disability. The law still uses mental retardation, however. It is only us psychologists that have, and psychiatrists, that have changed our language. The general statutes, as far as I know, at least as of a year ago, they hadn't changed. Maybe they've changed recently, but as of a year ago, they hadn't changed. Substance abuser, again, you can read this definition yourself. I'll put it up here. You can stop the slide here for a minute and read it for yourself. I'm not going to get into this. But you see, the second point here is the one that I had emphasized a few minutes ago. Using the substance by itself does not make someone a substance abuser. It must impair their personal, social, or occupational functioning. Now, lawyers didn't come up with this definition. They borrowed this definition. We psychologists and psychiatrists and other mental health professionals basically gave this definition to the folks in Raleigh, to the legislatures in Raleigh, and they made this as part of the law. And so lawyers didn't come up with this. They're just following what we psychologists, psychiatrists, mental health professionals have decided. Okay, and then dangerousness to self. As I mentioned, it is within the relevant past. They have shown these things as a dangerousness to self. That is, they're unable to care for themselves. They've attempted or threatened suicide. And the threatened suicide comes with, it's not just threatening to kill themselves. If that were the case, there are lots of teenagers that I have evaluated who would have been in the hospital that weren't. It's threatening to kill themselves and a likelihood of accomplishing it. Okay. So these are the definitions. This is the definition of dangerousness to self. Dangerousness to others, okay? Simply being annoying. And point number 1 here, simply being annoying does not make someone a danger to self. Does not make someone a danger to self. Now look at that future probability definition. The future probability definition says that it is in looking at future probability, we can look at their past behavior because the best predictor of past behavior, future behavior is past behavior. Okay, danger to others here within the relevant past. Again, okay, it does not mean, see number two, look at number two here. They have acted in such a way as to create a substantial risk of serious bodily harm to other people. That woman running through the red lights, for example, engaging in extreme destruction of property, which could possibly harm other people. Okay. And there is a reasonable probability that they will continue to repeat this pattern. Okay, so having done it doesn't render them dangerous to others. There is a good probability that they're going to do it again. And with this woman, there was a very good probability because she had this fixed delusion that was not going anywhere, and she was probably going to do it again, probably right away if we let her go. So the professionals that are legally eligible to perform mental health commitment evaluations. Now this has changed a little bit. An LCSW working for a registered agency can now do mental health commitments. An eligible psychologist does not need to be registered with an appropriate agency. Counselors cannot do mental health commitment evaluation. Why LCSWs? Ask the folks in Raleigh. Ask the folks in Raleigh. Okay. So these are the individuals legally able to perform mental health commitment evaluations in North Carolina. And by the way, this is pretty true in most other states as well. Pretty true in most other states as well. The procedures in North Carolina, affidavit and petition. You file the affidavit and petition with the magistrate. A custody order is issued. There's a first evaluation by a psychologist, and then the individual is transferred to a treatment facility, and a second evaluation is performed at the treatment facility. Okay, I'm gonna stop here because this is sufficient to give you an idea of the basic issues involved in commitment evaluations and involuntary commitment. Likewise, guardianship follows the same type of thing. In order to get guardianship, there has to be an evaluation by a psychologist in order for guardianship in most cases. Now, the evaluations can be waived by the clerk of court if there is sufficient evidence that the individual is sufficiently disabled to render them incapable of making their own decisions. But there needs to be some sort of evaluation to indicate that. This is where we're at here now. How does this apply to our case study for the week? Our case study for this week is is Chris Harper Mercer. The question that was asked about Chris Harper Mercer, was, why didn't somebody commit him? Why was he not forced to have treatment? And so the question that the individual is doing this week's or next week, I should say, case study is: could Chris Harper Mercer have been involuntarily committed, placed on guardianship? Could we have forced him into treatment to prevent the horrendous things that he did? Because he's one of these mass murderers who killed a whole bunch of people. So that is the question with Chris Harper Mercer. And the question to examine is, why didn't somebody do something about him before he did these? Because he was always an odd bird, had mental health problems before committing these horrendous crimes. And so that is the question to be asked. You've got enough information here to be able to answer that question about why didn't somebody do anything? What could people have done? What sorts of options were available? and how can we prevent this type of thing from happening in the future. But do you have any questions? I know you're only one person here, but any questions about what I've talked about so far?
Nope, everything seems pretty clear.
Yeah, today's stuff is pretty cut and dried. It's not all that difficult. And unfortunately, as I said, your book does not cover this area very well at all. It does very little on this topic. Well, if you have no questions, I will sign off. I will wait for Canvas to package the lecture, and then I will upload it into the proper place in the module. Okay, thank you for listening, and I will see, you're in the Friday class, is that right, Courtney?
Yeah, I'm in Fridays.
And I will see you day after tomorrow. You have a great rest of your week.
Okay, thank you. You too. Bye.